issues, because it's going to be really a very difficult but interesting, dynamics mapping out the intersection or interconnection. But as we know, AI, as said by Professor Madati, really has introduced very complex issues, complex challenges in our world. Hence, we are talking about intersection between intellectual property, human rights, and all other issues of justice pertaining to this matter. Hence, it is important, and I think the School of Law must be commended for being one, if not really among the first in the country at the moment, as in today, to be speaking on this particular issue, given the developments out there in the international arena. When you talk about revolution and you talk about AI, basically you really talk about the real revolution, because AI has influenced different spheres of our lives. You talk about in the health sector, you talk about finance, you talk about entertainment, you talk about also human rights issues, raising matters of intellectual property. And I think not long our government was also sitting and agreeing that it is going to allow AI means of addressing or attaining to some of the core business of the country. And I'm not here to give a speech per se, but I think it's quite also very important to say that given that we are in the school that talks about this particular issue, and I'm part of it, let me also, as part of going a little bit deeper into the papers, to indicate that artificial intelligence has reached the limelight. And thanks to countries like South Africa, we talk about Germany, Israel has done it, the UK, on the issue of intersections. The outcomes of the discussions are different. And I think that's what our panelists are going to be taking us through in terms of what we're saying. But then also really to see South Africa in particular, at the particular point, leading or groundbreaking in terms of the Companies and Intellectual Property Commission. I think it was on the 28th of July 2021, making history, publishing in its journal a patent on AI, and that Taylor invented this particular AI machine known as the device for autonomous bootstrapping of unified sentience, doubles to generate invention. And then you will hear from our members here, or our panelists right now, it went through. I've already talked about South Africa led at that particular point, when that decision was made, or when it was recorded in our intellectual property journal. It was the first globally, it is reported globally. There might have been behind the scene discussions around that, but then we were the first as a country when we do that. But then we also had Australia at the time, and I'm talking about information up to the end of December 2023, or at least towards the end of February 2023. We may be having developments that are basically really nullifying what I'm saying now. But I think it also shows how things are developing in terms of AI, hence this particular seminar and the importance in terms of its purpose to both our academic and to our life experiences. Australia Patent Office at one point refused to proceed with this particular application just for the fact that none of the provisions in its intellectual property or patent legislation did exclude the inventor from being a non-artificial intelligence device system, but then you had a different judgment by the full court 13 differently there. I'm not going to go there, that's not my area of specialty, but then I'll also indicate that, you go to the European Patent Office, that initially said, we cannot get into that particular space because we're talking about machine, and the machine cannot be regarded as a patent holder. Hence, the legislation at the time, remember, this decision, when they are made in the context of the legislation as it is pertaining. And it also went down to the UK High Court until the last was the end of the year, when the UK Supreme Court finally really issued out a decision that confirming the Dabas II case, confirming that AI machines cannot be inventors. But in many of these, jurisdictions, there's always been a little bit of an exception in terms of, yes, may not be, there's an inventor, but then nothing prevents, individuals from using AI in terms of invention. Here I'm thinking of the German Patent Office. That basically came almost to the same, what I'm saying, in November 2021. With that said, the purpose, in summary, is really for the specialists that are invited here, for the discourse that's going to ensue here, to help us understand that first, we have gone way beyond as we receive AI. And also, how is this impacting on our daily life, the different facets of our life? Like, for instance, we talk about intellectual property. But it's not only that, issues of human rights. You are talking about issues of service delivery. You can even talk, as Professor Madani said, talks about issues of education in general. With that said, I hope that we will enjoy. I'm looking forward to hearing what our experts are saying. Thank you very much.
Thank you, Prof. I'm reminded that I should inform colleagues that there are bathrooms. Just turn right, you'll see the stairs on your right. That's where our restrooms are. With that said, allow me to move swiftly to item number 3. Can we give a round of applause to Advocate Mangambi as he comes to the podium?
And if you are failing to sing that, you might have a problem. All right, thank you very much, Program Director. Thank you for this opportunity. Let me start off by saying, actually I want to quote a song by the late Zahara. May her soul rest in peace. And she said in the song, featuring DJ Spo, and the song is called Ngiyatandaza. She said, I will read because I'm told there are Xhosa-speaking people here. I don't want to make a mistake. In the song she said, Ngiyatandaza, uyivele ngoma, izovuselela umphefumulo wakho, ikunike ithembe elitsha. I know Prof. Neil might not pronounce it well. And close quote for those who don't understand what the song is all about. It says, I'm praying, so that you listen to this song. And after listening to this song, then it will give you the hope and courage and a new, I don't know how to put it better. So the reason I quote this as school from the School of Law, before all the speaker that I am going to introduce to you, we are also praying that you listen to our presenters. And rest assured, after listening to them, the way you look at things, the way you do things is going to change from today. And let me start by thanking the DVC, Professor Mataje, our Executive Dean, Professor Sibanda, Director, School of Law, Advocate Mashele Rapata, fellow HODs, and also a guest from LPC, from Polokwane Bar, from SASA, from examination. Yes. Our own Ms. Muleleman. In a busy schedule, she said, I'll make it a point that I come so that at least the issue of AI, she's dealing with the same on a daily basis. The law firms, candidate attorneys, and actually let me just say, and everyone so that I don't exclude any other, but lastly to our beloved students, we want to say we know most of you were done this exam yesterday, and we say, no matter how difficult it was, we will still go there and see them. Thank you for coming. All right, my task is very much simple, is to introduce the guest, and of course we should say this as department, it is something of a very precious and rare privilege to be able to gather different expertise on the issue that is of a current, on the issue that on day to day we face, and to have that privilege to gather all the expertise who are here today. It is something that we'll always cherish, and it will stay with us for the rest of our life. I will start when I'm done. Before I go to the next, I will ask colleagues to welcome them with warm hands of applause, because we know for them to be here is a grace, and we thank them for gracing us. All right, our first expert is, her name is Umphile Nechiozi, Director of Umphile Nechiozi Incorporated. Ms. Umphile Nechiozi is a registered patent attorney and Director of OMN Attorneys Incorporated, a law firm specializing in intellectual property, commercial and corporate law. She has been there for 18 years. She has 18 years of experience in the legal field, the vast majority of which is in intellectual property. Having held various positions in private practice, corporate and public sector, she has well-rounded experience in dealing with the various legal aspects that enable and affect intellectual property management, protection and commercialization, as well as the corporate and commercial legal aspects of operational businesses. And the topic and the knowledge that she's going to share with us is on the very same, which is the intersection between the AI and the IP. Ladies and gentlemen, allow me to join me in giving the hands of applause for the first speaker of the day. And Director, maybe I must confess, since Prof. DVC is here, that I was not part of the organizing. As you hear the names and everything, I was not part, it was just a coincidence that the experts that we found and were very popular happened to share the same. So when I read their surname, you can hear I'm very much comfortable. So it was not my own doing. All right, our second speaker is Dr. Rendani Mampiswaka from Nafasi Water. Rendani Mampiswaka is an innovation expert and policy scholar, trained as a process engineer. He has diverse professional experience in chemicals, energy, water, non-profit, public policy, and academia. He is head of research and innovation at Nafasi Water Technology, Pty Ltd in South Africa, where he leads commercialization of technology and business innovation. He lectures, conducts research, and supervises postgraduate students on innovation and policy at Wits Business School. University of Pretoria, and University of Johannesburg. He currently serves in various other roles such as board member of Innovation Hub, a subsidiary of the Gauteng Growth and Development Agency, advisory board member of the Faculty of Engineering, Built Environment and Information Technology at the University of Pretoria. He was a member of the South African Presidential Commission in the Fourth Industrial Revolution. He is a TEDx speaker and holds a PhD in Innovation Policy and Management from the University of Johannesburg. And the topic which is going to bless us with is developing and managing the emerging artificial intelligence technology, the role of innovation policy. Ladies and gentlemen, join me with a heavy hands. I've confessed, Director, that remember the issue of reading is not only our former president. And do not think I said, no, here I can be comfortable to read these psalms. All right, ladies and gentlemen, again our great speaker, who is the next now, is Professor Lonius Njov. He holds, that is PGD, IP, LLB, LLM, LLD, advocate of the High Court in South Africa. Lonius is full professor and director of the School of Law at the University of Venda, which he joined August in 2016. He serves as the Dean of the School of Law at the University of Venda from 2019 to 2021. He holds the degree of Bachelor and Masters of Law from Fort Hare and Doctoral of Law from UNISA. He also has a postgraduate diploma in higher education with numerous distinctions from UKZN. Before joining the University of Venda, he worked at Fort Hare, Zululand, Northwest Universities. At the University of Zululand, he occupied managerial position as the head of the Law Department and Vice Dean. Lonius is an advocate of the High Court, like I've said, and runs a limited commercial law practice, researching, consulting, and advising on intellectual property and public health issues and commercial law matters. His area of teaching and research interests lie in intellectual property law generally, intellectual property and access to medicines, international trade law, labor and commercial law, as well as corporate law. Recently, he has consulted for SADC, COMESA, Third World Network, RIPO, and WIPO, where he currently teaches on prestigious global public health. Lonius is a member of the African American Society of Intellectual Law, Asian Society of Intellectual Law, African International Economic Law Network, Society of International Economic Law, and the South African Association of Intellectual Property Law and Information Technology Law. Ladies and gentlemen, you are very much teachable. He is going to bless us. He's going to talk about on DABAS, patent law, and AI. What is the story 5 years later? And I can't wait to hear the story 5 years later. All right, our next guest director is Professor Sizwe Snail Kamtuze. I hope I did justice in mentioning the son. Prof, he holds LLB, LLM, LLD, admitted attorney of the South African High Court. Caesar Lindelo Snail Kamtuze holds LLB, like I said, from the University of Pretoria. Previously worked at Cousin, Herzog, and Horak, Pretoria as an attorney from 2007 to 2010. He's a practicing attorney with law firm Snail Attorney at Law since 2010 to date. He holds an LLM from University of South Africa. Sizwe is registered with the University of Fort Hare for an LLD. Sizwe is an adjunct professor at Nelson Mandela University in the Department of Mercantile Law from 2020 to date, and supervises postgraduate students, and which is LLM, and has been a research fellow from 2014 to date, as well as the lecturer in the field of cyber at the University of Fort Hare since 2018 to 2022. Sizwe also is an advisory member of Cyber BRICS, FGV Rio de Janeiro, Brazil, 2019 to date. And Sizwe is also a visiting professor at CTSFGV Rio de Janeiro, Brazil, since 2022 to date. Sizwe was a member of the South African Information Regulator, which is IR, from 2016 to 2021. Sizwe was a member on the ICT review panel of the Department of Telecommunications and Postal Services, which is DTPS, serving as a chair of the e-commerce committee, Digital Society as renamed. Sizwe served on National Cyber Security Advisory Council of the DTPS from 2014 to 2016. He was a deputy chair and a chair for the Law Society of South Africa, which is LSSA, E-Law Committee, from 2013 to 2021. He has been the domain name mediator for ZADNA, which is the Domain Name Authority, since 2017, and a member of the Films and Publication Appeal Board from 2016 to 2021. Sizwe was the co-editor and author of Cyber Law South Africa, which is one of the books that is prescribed in our final year students. We make sure that you must meet the author in person. And he is going to bless us with the law of the internet in South Africa. No, that is on the book, the law of the internet in South Africa, 2012, but also the cyber law of South Africa. The law of internet in South Africa, which was published in 2022. Ladies and gentlemen, can you join me? Thank you very much, Program Director. I appreciate it. Thank you.
Thank you, HOD. Colleagues, we are going to move swiftly to our presentation without wasting much time. This is how it's going to take place. We are going to allow our presenters to come and present, and then once they are done, we have moderators. We have Mr. Ngwane as well as Mr. T. Lebelo, who are going to come and lead those discussions. So we allow them to present. Subsequent to that, then we are going to have a discussion. So what it means is that while they are presenting, if you have questions or comments or whatever that you want to engage them with, you just write it down. Then once they are done, you'll be able to pose those questions and comments. With that said, allow me to call upon to the podium Professor Snail Kamtuzi to come and give the first presentation. A round of applause, please.
Good morning, everybody. Maureen, as you've correctly identified, or been identified, I'm Fossa speaking. So, thank you for having me here today. I would like to reach out to the TVC. I'd like to also reach out to the dean of the faculty, as well as the director of the School of Law, and thanking them for having this event and allowing us as the speakers to come here at this prestigious event to share some thoughts with you. So without further ado, I want to talk to you in particular about artificial intelligence and human rights. When I saw the topic, the intersection between artificial intelligence and human rights and IP, I said to myself, well, I need to confine myself to a particular area of discussion. In other words, I don't want to be all over the place talking about IP and then talking about this and that. I decided, let me confine my talk today on human rights strictly. Now, what exactly is artificial intelligence? Now, it is a buzzword. It is a buzzword that has been used in the last 5 to 10 years to describe a form of intelligence which is artificial in the computing world. That is my short and sweet summary of artificial intelligence. But this is not a new thing. As early as 1956, there was a scholar by the name of John McCarthy, and he was the one who said, look, we need to start finding ways in which we can teach technology to not only mimic the way we think as human beings, but also allow technologies to learn as they go and to mimic the intelligence of a human being. In other words, also the ability to not just reproduce the code that's being put in, but to actually create other code. Okay? So this was as early as 1956, and I'm happy that the different revolutions were pointed out earlier on. The first revolution, the second revolution. And at the time John McCarthy was talking about this, we should say we were in between the third and the fourth industrial revolution, right? We were somewhere between creating the microchip and the condenser computer to where we are now in 2024, where we have supercomputers on our little smartphones, okay? The computing capabilities that a smartphone has now, right? If you go back in the days of John McCarthy, would have probably filled this entire room, the infrastructure of that technology. So, over the years, this issue of artificial intelligence, it extended itself. The issue surrounding ethics in artificial intelligence started being an issue, right? The first scholars, before even us lawyers, to deal with the ethical issue in artificial intelligence was actually our computing scholars themselves, right? The computing scholars started being concerned about the ethical use of artificial intelligence, right? Now, the moment you start talking ethics, what do you trigger? You trigger the Borimores. You trigger the convictions of our society. And if you do that, you trigger the law as well, okay? And in this particular context of the human rights, as I'm putting it, you're triggering the Constitution and you're triggering any other law that protects any rights in the Bill of Rights in particular. Now, when looking at the Constitution, right, our Constitution has a Bill of Rights. I'm not going to regurgitate that, but there are certain rights that may be trumped either by the use or the deployment of artificial intelligence. Now, I'm not going to go in any specific order, but I will choose the right to equality. Let's start with the right to equality, right? I've had the pleasure, as you heard earlier on, of being a visiting professor in Latin America. And when I'm there, I attend numerous conferences such as the CPD Latam. And one of the issues that has really come out there is the biases that AI has in law enforcement, okay? It has come out clear now, there's empirical evidence, scientific evidence, that if you train an AI machine using Caucasian faces, all right, and then you try and identify persons of color, right, using the same AI technology, you are likely to create AI biases, okay? Did you guys hear me? AI biases in the algorithm itself. Now, once you are biased, what are you doing now? You're not treating people equally anymore, are you? Right? So if you're not treating people equally anymore, you are trumping that right to equality. Okay? So one needs to start thinking, like I said, initially it was the ethical concerns. These ethical concerns then became legal concerns, and these legal concerns also tally with the Constitution. Another right that one can look at is the right to privacy. Now we all know about ChatGPT, don't we? Right? I hope we don't know about ChatGPT because we got busted, because we were trying to use it for assignments. I hope that's not your interaction with ChatGPT. Right? ChatGPT is a very powerful tool. Right? It allows you to search information, and in the same way it uses these artificial intelligence algorithms, right, to learn and to develop the databases that it has, and also to give certain results. Now, the problem that we have with ChatGPT is that it collects, and all these other AI search engines, they collect a vast amount of information. Okay? Now, information can be split into two categories: public and non-public information. Do you guys agree with me? Yes. So public information is what is out there. It's what people put on their websites. It's what our government wants us to know. It's what people publish. It is out there. We want it out there, right? But then we also have personal information. Now, personal information is information that is exclusively to you, which you most probably do not want shared with the outside world. You don't want your cell phone number shared with the outside world. You don't want your ID number shared with the outside world. You don't want your residential address shared with the outside world. Now, I don't want to make this a Popia lecture, because that in itself would take the entire morning here. But the use of personal information by AI tools, right, when you are training AI tools, that could also infringe upon the right to privacy, right? Have you ever thought about this, that every single time when you install a piece of software on your computer, on your mobile device, and it asks you for your name, it asks you for your birthday, it asks you for all this personal information, have you ever considered and asked yourself, where does this personal information go? What do people do with it, right? So what they're doing with it in these days is that they're processing it in the form of big data now, and AI algorithms are also using this information to give certain predictive information which can be used for other tasks as well. So the right to privacy, like as I said, is one of the issues which one really needs to consider in the deployment of AI as well. Then also the right to freedom of expression and the right to dignity as well. And you'll say to me, the right to dignity? Yes. I remember a couple of years ago, there were some high school pupils who were convicted in the criminal court and sent to juvenile detention in Pretoria because they had used a software tool to use the face of the principal and place it on a naked man's body. Right. Now, that was so rudimentary at the time. It was probably a silly copy and paste job using a silly rudimentary editing tool. The powers that we have now these days of taking a picture and taking and asking an app to actually put your face on another body, be it on a pornographic body or any other profanic manner, is something that happens every day. So people's dignity is also being violated because of the use of AI tools. We make it easier now to create, should I say, distasteful content, right? I'm sure you go on social media, a lot of the people in this room, I'm sure, are social media butterflies. You see all sorts of pictures of all sorts of politicians doing all sorts of stuff. I mean, I recently saw the one of our former president and our current president to be dancing and all that. That was made its rounds, you know. I guess the dignity was not violated there. You know, we actually found that one quite interesting. But there are other distasteful, should I say, products of AI which one really should decry. Now, I don't want to talk too much about AI regulation, but I think it is important, as set out before, I think it was Prof. Savanda, to say that in terms of our policy, our South African government has taken a stance to say that artificial intelligence is a reality. It is a reality. We need to have AI institutes. We need to start teaching artificial intelligence in our curriculums. We are starting to use AI in our daily lives. And as I said, one of the aspects is this whole issue of human rights. Okay? As I said, I don't want us to stray away from the topic. I don't want to steal away the thunder of the other speakers. Now, for instance, if you look at the POPIA, the Protection of Personal Information Act, it has a section, namely Section 72 thereof, right? Section 72 thereof, read together with Section 5. I promised myself I was not going to come and lecture here today, but here I am lecturing, right? Talks about the right of a data subject not to be subject to automated decision making, right? And having the right to review same. So what does this mean? So a bank has vast information about yourself. What information do they have about yourself? Well, they know that on a certain day, X amount of money comes into your account on a frequent basis. So they know that, don't they? And on the basis of that, they can offer you certain products and services, right? But this particular section now says, you can't just make a decision. In other words, you can't just upgrade me from one package to another package based on the information that you have and automatically take a decision about me. If I like my classic gold card, I like it. I don't want your black card. And do not take a decision for me, right? POPIA outlaws this. You cannot make a decision for me. Yes, if you want to, offer me the black card. Tell me, based on the information that we have, and based on the money that we see coming in, our algorithm tells us that you are a possible good, customer for this and that product. But you may not, as a bank, use automated decision-making processes to take decisions against me or for me or in my favor. So that's just one of the aspects that I want to point out. Now, there are numerous decisions concerning AI in the courts in South Africa. I don't want to go into those decisions. I think I'll leave those decisions to my learned colleagues to exploit. But where I do want to go is the whole position of artificial intelligence on the African continent. Okay? In my previous life, I was very much into data protection. And it was all about creating an African data protection principle or an African data protection law. We have now reached that stage as Africans where we now also want artificial intelligence norms, right? African norms that guide us and that also inform our human rights, as well as our socio-economic development as African states, right? And the AU, as early as 2021, during COVID, they came out quite clear and they said, look, this whole issue of artificial intelligence is something that we need to have a work study on. We need to start having discussions on this. And in the last 2-3 years, I must tell you, Africa has not been a dark continent when it comes to AI. Africa has been glowing, okay? Africa has been glowing. There are also efforts by the AU together with the NEPAD to come up with an AI strategy, right? a big draft document has been circulating since February concerning a strategy for African AI. How do we as Africans use AI to our benefit? How do we use AI to take us out of poverty, right? These are some of the strategic objectives that we have in terms of AI and the human rights perspective. When people talk human rights, they always think, well, you know, the right to freedom of expression, the right to privacy, as we mentioned, but we never talk about the socio-economic rights. We never talk about the impact that AI can have on our socio-economic rights, such as education, right? Sending out education, making education more accessible, also having educational tools, right? This is one of the responsibilities of responsible AI deployment, right? And also using AI to reach out to those communities where an ordinary could not do so due to lack of technology. So I don't want to steal the thunder from the next speakers on this point. I see there is a session where we're going to be asking questions and answers. I'm on a roll right now, so I want to stop it right there. So if the program director can excuse me until the Q&A session. Thank you.
No, thank you, Prof, for that wonderful presentation. May I call to the podium Prof. Nelson Lofu from UNIVET to come and give us the next presentation. A round of applause, colleagues.
The mic was about to discriminate against me. Yes, because today is inauguration, let me start off being a little Party University. You are hosting us at this prestigious institution. We really appreciate you and colleagues from the VC's office. Let me go through my protocols and go down. So I really also should acknowledge the Executive Dean Mosband at that time for allowing us to come here. And then of course going to my HOD who's sitting there. I'm from the Department of Mercantile also, my HOD who's sitting there. I appreciate that for HOD, and then Tabo and colleagues from the Technology Transfer Office, we really appreciate you colleagues. And then of course my way to the colleagues I'm going to speak with, I really appreciate you and colleagues in this room. And very importantly, students who are in our midst, we appreciate it. It's a good thing, it's a good opportunity to be here. I will not introduce myself, my HOD has already done it, I appreciate that. But I am talking the Davos dispute which Professor Sivanda, I appreciate your generosity, introduced it for us. And you have done the job for me, I don't have to be doing much. I'm very close to the conclusion already. And, but I am, this is part of along this project, where I'm actually looking at AI and saying, we have read in the literature that there is quite this pressing need for AI to be regulated. And we've been talking quite a lot about it. And Professor Snail has hinted at delving into a bit of history. I mean, when AI actually hit us quite a while back. But when you look at the regulatory regime, have we been moving at a pace that's actually appropriate, for technology? And I'm going to go into the Davos issue and actually, not on a very hopeful note, that if you look at what happened in the United States, in the UK, in Australia, and then in South Africa, you see that the law has not been moving as fast as it should. So that's my story, really. You said you're looking forward to the story 5 years later. The story 5 years later is very gloomy, and we are saying, despite the fact that in South Africa, let me confine myself to South Africa, there are so many legal academics, there are practitioners, there's even the CIPC, which is overrun by IP attorneys there. We haven't had enough energy to actually influence the law reform that we wanted to go around. So I thought, when you're about to eat a meal, sometimes you just want to start off with light material. The starters are just to take people back into some bit of history and highlight the importance of AI. And at least say, we know it's riding at the back of technology, and some of us we still remember the Y2K issue then, and it was so important then that it even featured MC News in Sisu. I don't know how many of you were watching that technology. Millennium, not millennium. It was millennium then, and those were the fears. And then now you see, Professor has already hinted at it, that AI is quite an important tool, but we are worried about how it's likely to trample on other human rights. And one of them is actually, we are looking at inequality issues. Then other scholars on the other side, they view AI as an opportunity to actually conquer this inequality. And then, of course, we have already opposing views there. And I'm saying, as I hinted at the beginning, that we're looking at the law having a role to play. And then how does the law then, play that role? We have to develop the law such that it actually keeps pace with what's happening. We appreciate the fact that we have had a presidential commission. We appreciate efforts at the AU level. The European region as well has actually moved faster than us, but we are actually saying, if you look at regulation of AI globally, nationally, you see that we really haven't made much progress. So the research question, we have students here, for your LLB dissertation, here's the research question. Is South African patent law developed enough to look beyond human invention? That's the issue I'm talking about on Davos there, and I will actually take us through what happened at the CIPC, what they looked at, and what I think, I'm just expressing an opinion, what I think ought to have happened. And then I'm talking about the law being reformed, and I'm saying academics are quite notorious for being caustic critics and then not coming up with possible solutions. I'll be a different academic today. I'm going to be a caustic critic, and then at the same time I'll tell you where the intervention should actually happen, at what stage, and what we should do to avoid those Davos accidents, as it were. I thought because the theme of the seminar is AI, there's human rights, there's IP. I'm specialized in patent law as well, and I'm saying, I thought, so that everyone here does not accuse me. So that everyone here doesn't accuse me of making things up or speaking out of tune. I thought, just to make everyone comfortable, that I'm familiar with human rights, I'm familiar with AI, I'm familiar with IP, just for you to see how these relate. So you will see on AI, they're actually riding on the back of the fourth industrial revolution. Most of the things that we say AI, they are products of the fourth industrial revolution. And then I found something very attractive about AI, like talking about the science of making machines do things that would require intelligence if done by men. And that's an author there called Anderson and his colleagues. And then we are going to talk algorithms in AI. Everyone here has heard that word mentioned, but I'm not going to make life easy for you and start going into what algorithms are. But we're just looking at a number punched into a computer, you are feeding them certain information so that they predict future behavior. And then of course with human rights, appropriately has done a great job there. But we are actually saying quite a number of human rights are affected by AI. Then I've just zeroed in on the right to food, for example. If you look at someone coming up with an AI technology that makes it possible for us to predict droughts, let's say. We have a drought this year, where climatologists, they were telling us there's something called El Nino and something called La Nina. They've been grappling with these things for quite a while. If we come up with something that actually tells us that, look, 3 years from now we're going to have a drought, and then we can stop. Or, AI technology is assisting us to actually come up with pesticides that make it impossible for all our common pests that affects our harvest. And then we're saying that's the story. Again, you invent certain machines, and then they end up exacerbating the effect of climate change. You are already affecting the right to food there. So people are worried about AI on the negative side, resulting in discrimination, inequality. My colleague Professor has spoken about accessing services, and then creating a hierarchy of those that have access to services and those that don't. And looking at our situation here in a university context, I'm taking us back to the days when COVID hit us. You will recall we went on online education, really, remote learning. And the major struggle then was that students and the rest of us in the academy, we were screaming about, data and how to access that. And even when interventions to make that available to students were available, and that problem still persisted. And then if you can look at AI in our context, we are here, maybe the data challenges have gone down a bit, but we can't compare ourselves to students in other parts of the world, let's say in Japan, Germany, even the United Arab Emirates. For them, those things we are worried about, data and so on, those were worries for them, worries in the past. And then we're saying now, here's AI as an opportunity to improve our lot, but we're actually saying, looking at how wealth inequalities play out, we'll create a hierarchy of those that have better access to AI than others. And then, of course, in the IP sphere, AI permeates everything. And then in the context of what I want to talk about, I did write something, I think, in 2020, when I actually wrote on the potential of AI to be used to improve patent searches and examinations in South Africa, such that we then can isolate those inventions that really deserve to be patented. Because again, you will hear later as I zero in onto the Damus dispute, or not a dispute, we call it the Damus saga, isn't it? That the main criticism against the South African patent law has been that the formal and substantive examination, and that we do what is called formal examination. And that's part of what I bring in as criticism. For the record, maybe I don't want people to be in suspense for long. My position is we registered Damus as a patent in 2021, but that registration was premature in my opinion, because we should do, whatever we do, we should be guided by the law. So if the law doesn't permit it, we must reform it. You can argue that there's purposive interpretation, but I think that purposive interpretation, no matter how much you overstretch it, it was not supposed to be. You saw that argument also playing out in a different context, right? when a particular individual wanted to be in parliament and then they were told the conviction prevented them from there. And then people argue purposive. Sometimes purposive can be, you can take refuge there, but it doesn't really avail itself all the time. So the long and short of it is that the message I'm driving across through my presentation is that the law is crying for reform. And as long as that reform has not yet happened, we can't be too creative and actually attribute to the law what it doesn't do at the moment. And then that slide, I worked on it before I knew that we were going to have Professor Snail and Professor Sbanda and others talking. So I'm just adding on what they're talking about. Look, different spheres where this AI can come in. You can look at it and say, will this be beneficial? What is the potential of rights being violated there, for example, in AI and climate change, or AI and labor law? When we automate things, we look at South Africa, our high unemployment rates, or what are the positive and negative spin-offs? Some of you can argue that, look, we automate production, we are more productive, the economy develops faster, but then what are jobs as well? There's lots of unemployment and all those things, so those balancing acts can be struck. But again, I'm really overkilling the point here. AI being viewed, aspects of AI are being viewed as threats, as problems. Some people say, look, these things that we regard as threats are actually possible opportunities. And I give you a preliminary list there, which is not really exhaustive. Some argue from a gender perspective, some argue disparities, balkanization of society, some argue, from a labor law side. So I want to quickly move then to in the beach now. That's the story for the day. That is what I really wanted to talk about, the Davos invention. There is an individual there called Dr. Stephen Penner, who invented an AI machine. And then this AI machine, since we say it in defining AI, is that you are actually giving machines human-like attributes. Although these human-like attributes are not necessarily all of them. For example, a machine cannot get angry, it cannot fall in love, it cannot feel like you are boring it. Like now, some of you are feeling to be talking and you don't like it, human-like attributes. But I'm saying, let me then take some of us through the facts so that we're talking about the same story. We start in 2018, really, where Stephen Taylor creates his AI machine called Davos, and then he files a patent application in the United Kingdom, tries something in Europe through the Europe Patent Office, files again in the United States, and then he names that machine, which is an AI machine, as the inventor. And what the machine was supposed to do, really two things. Right? He sought a patent for a novel food or beverage container, and then an innovative light beacon. Those two things that the machine was bringing to the fore as a product that can improve humanity. And then if you look at between 2020 and 2022, the application for a patent was rejected by several offices and even courts. Look at the UK, US, Australia. And then I think I've browsed through the literature, I found some colleagues, I think, Doris Talda and Naidu, and then there was Professor Oreko on one side. Talda celebrating the fact that the Australian court had initially ruled that, in Australia, that invention had initially been ruled as patentable, but then later the issue was thrown out by the full federal court of Australia. And then, of course, why were all these courts rejecting this? They were actually saying, if you look at the law related to inventions, in South Africa, I think Section 27 of the Patent Act, you will see there that, although in South African law we don't define a patent, but then if you read section 27, especially 27.1, you see there that the insinuation is that it's actually a natural person, because it's talking about the he, there, and it's actually, I'll go into the section later, show you the details. And then, in line with the reasoning of these other courts in the United States and other countries, the inventor must be a natural person. And then we are looking at January 23 home. We grant that patent. And we have our own reasons which I will delve into. But in summary, that is what happened in terms of rejecting it. And then we get our consolation on point number 5 there. Right? It comes to us, we accept it. AI is recognized as an inventor. So, the essence of what I wanted to share today is, I'm looking at point number 5 and saying, AI was recognized as an inventor. What was the basis? Why am I uncomfortable with it? And what should be done? Right? And then you will see that decision to grant the patent in South Africa was celebrated across the world. And we were feted as a country that leads in everything. You are aware, we led in dismantling apartheid. Right now, as I speak to you, we are leading on the Palestinian question, which is quite a positive thing. We are leaders also, if you recall, on the Truth and Reconciliation Commission. We are regarded internationally as leaders in negotiating and finding negotiated solutions. And then I think my HOD hinted at that, talking about innovation and the GNU. I was saying we've been scoring firsts everywhere. Right? And then I'm saying this first is something that I feel is really requires further interrogation. So the question is, why do I keep saying it was wrong to grant that patent for campus in South Africa? Are we saying the law is behind, is the law backward, is it stagnant, or is it anti-technology? And when you look at the law as it is now, why can't we just apply it? And I think the CIPC said, here's the law, we just apply it, it still applies. And then I thought maybe here, in order not to lose some of us, we should perhaps lay bare some of the provisions that we would assume the CIPC would have reliable. If you look at section 25, which basically sets out for us what qualifies to be an invention, I don't think at that stage there was any need to look at section 25. I'm just bringing it here for completing the picture. But otherwise, an invention is called an invention if it is new, if it involves an inventive step, if it is industrially applicable. And in South Africa, we actually say if that invention is applicable in industry, trade, and agriculture. So we assume at that stage, DAPUS, if we're a patent examination regime, DAPUS would have satisfied those requirements. Colleagues, you are aware that the CIPC, and my colleague in practice, the reality is, we know we recently hired patent examiners, but they can work in certain fields. But all along, and I think up to this stage, when a patent lands, a patent application lands with the CIPC, our colleagues there don't look at the patent from a technical point of view and say, is the patent, what is claimed in the specification, does it really exist? Can it happen? Is it, technically speaking, have you actually typed it out in blank ink? So you're not looking at whether technically the invention will satisfy what is defined as an invention in section 25. So now you go there, the most important provision, as I highlighted earlier, would be if you want to check whether a machine can register a patent in its name, then you have to check in section 27. So does section 27 contemplate a machine being an inventor? If you look at it, who may apply for a patent, this may be made by the inventor or by any other person. I hope our law has not evolved to the point of calling a machine a person. Maybe our students can tell us better. And then acquiring from him. Again, we don't attribute these issues to machines. The right to apply or by both such inventor and such. And then in case the patent is commercialized, then they can get something. But then, from the provision in section 27, then, it is not clear that the inventor, is it not clear that the inventor must be a person? In my view, I think it is clear. And then, the inventor is not defined in the Act, that does not really derail us that much. So, if the inventor must be a person, I'm not sure if AI can do that. Then you will see that I think, yeah, it was Professor Banda in his opening remarks. He actually hinted at the fact that, in the European Patents Office, the legal board there opined that it was not aware at that stage of any law or any case law that prevented the user or the owner of a device involving inventive activity to designate himself as the inventor. I was simply saying, you are the creator of an AI machine. Your name is Lonias Ndlovu. You created that machine. The machine does certain things. It comes up with a novel thing that can be industrially applicable. There's no law that stops Lonias from designating himself as the inventor because he's the brains behind that machine. But then in this particular instance, Dr. Taylor designated the machine itself as the creator. Because artificial intelligence descriptions or definitions tell us that we can give machines human-like attributes. And then in our case in the CIPC, the Doubles machine is indicated there as the inventor. And very disturbingly, it's actually given an address, right? That it stays at this particular. So machines have addresses now according to the CIPC, and then it's listed as inventor. Quite interesting. And then we are actually saying some of the arguments that were advanced were that, look, if you go to the law property, or law property being based on Roman Dutch law, look at the concept of accession. He who owns a corporeal, then if the corporeal creates new property, the owner of that corporeal then owns the new property created. But then in our case here, Doubles, this says the machine owned by Dr. Taylor. If it creates something which results, that's something being intellectual property. Intellectual property is not a corporeal. So the concept of accession would not really easily lend itself to that interpretation. And then we go into our law, we look at if you are inherit or you want to enjoy the rights, creative rights as a patentee, and originally you were not named as a patentee, then we can transfer those rights to you through an assignment. If you look at regulation 22(1)D of the patents regulation. Again, we go back to our application before the CIPC. There was no such assignment, but CIPC still went on and said, that's the story. And again, if you look at how an applicant derives power from the inventor, that one, you look at Form P3, which is basically a declaration in power of attorney. That is where you actually declare that the power. Now just inventing this particular person. Those things again do not happen. So we are looking at, if you look at section 34 of the Patents Act, if you are applying on behalf of another person, or you are acquiring the rights from another person, you should compare the circumstances. So, in my humble opinion, I'm saying the CIPC should have rejected that application because our law does not contemplate an inventor who is not the law is archaic, it should be developed. But the right course of action would be, then why not amend that law? And then say, you know, and then make sure that you actually accommodate these machines. And then my suggestion would be that if we accommodate these machines, we must then not lose sight of the owner or the creators of these machines, so that we can then have some kind of special regime I can call sui generis, where if the invention comes from an AI, then maybe we can say the owner of that AI becomes the inventor themselves. So you can see, for example, rejecting the notion of an AI system like Davos being an inventor, but I'm simply saying the law as it kind of is there, cannot accommodate. Then I'm also saying the notion that inventions created by AI should be patent protected. Yes, I agree with that, if they satisfy the requirements of research. And inventions, as we know them in this world, even before Davos came into the picture, most inventive creativity of machines. And no one has ever come and said, I'm registering this patent, my machine XYZ created it. So why are we suddenly conceptually struggling in this particular instance? And then I'm saying the current South African law, as it is unreformed, is in line with its counterparts in Australia, in the UK, in the United States. The laws in those countries and in South Africa obviously cry for reform in that particular instance. And then I just want to say, you know, in my conclusive points, I'm still, you know, kind of repeating myself most of the time. I'm just raising this for emphasis, the long and short of it being that I'm sure the registration of Davos in South Africa, in as much as it was celebrated, I think it was premature. We ought not to have celebrated it. And then, having said that, because we're in AI mode, as I was preparing to come here, I saw something that was shared on social media where, you know, these days with social media, TikTok, everyone has become an expert in this and that. So someone was busy screaming there that we are in Africa. If I'm at home, my son went to Joburg, a year has passed, I go behind the crowd, I speak to the ancestors, and then 2 weeks later he's at home. Is that AI? Maybe we can leave that. Thanks, sir.
Thank you, Prof, for that wonderful presentation. Colleagues, while the speakers are presenting, can we refrain from tampering with the mics? Because when you switch on, wherever you are, it switches this one off. And then in the process, it disturbs the speaker. Okay, can you refrain from that? It's just a plea. You know, someone just did that. Can we refrain from that, colleagues? Please, we plead with you. Allow me, colleagues, to then call to the podium Ms. Umpilo Mudiba from Mudiba Incorporated. A round of applause, colleagues.
Good morning, everyone. I'd like to start by thanking the leadership of the university for inviting me to come and talk on this very interesting topic. And I'd like to take an opportunity to thank my colleagues in the TTO that I work very closely with to put this on my shoulders as an IP attorney in inviting me to come and present my perspective on this topic. And thirdly, I would like to thank Prof. Ndlovu for taking about a third of my presentation. So I should be very short and finish rather quickly. The issue that he just talked about, I covered it in quite a bit of detail in my presentation. And I think in view of that, and in view of the level of detail that you've gone into, I'm not going to spend a lot of time on it. But I think in summary, I actually do agree with you in the sense that even if South Africa is a non-examining territory, the formal examination process itself should have picked up the discrepancies in the application that was filed by Stephen Taylor in respect of doubles. So if you look at section 27.1, in as much as it appears in the Act, in the substantive part of the Act, it actually is a formal requirement. It is not a substantive requirement, and it should have been picked up by the CIPC. And we hope that at some point that this patent will actually be brought either on review or maybe an application will be brought for it to be revoked so that we can have some guidance in terms of how AI should be treated from an inventorship perspective. I think across the world, with the rise of AI and the use of AI and the integration of AI in our daily lives, the world is grappling with the regulation and the governance of artificial intelligence. There has been several, as we've seen in respect of IP, there has been several discussions going around in terms of how do we regulate AI. And I think this is brought about by the fact that AI so much resembles human capabilities. And with that, there is the temptation to want to grant it human rights or human obligations, which without giving much thought to the implication of that and whether it actually does meet all those requirements or all those characteristics of an actual natural person. Sorry. Okay. So I just want to put this in presentation mode. In 2023, in April, the Harvard Business Review published an article which I think summarizes the issue with AI and intellectual property. And it ran the article with the title, "Generative AI has an intellectual property problem." But the problem is defined very differently depending on where you're sitting. And what the article sought to highlight was the challenge of the use or the unauthorized use of copyrighted works by developers and companies that own generative AI in the training of AI, and proposed measures that should be implemented in order to address these challenges. On the other hand, WIPO, which is the World Intellectual Property Organization, which is a leading organization, a worldwide leading organization in respect of intellectual property matters, and of which more than 157 countries across the world are members of, is been leading engagements around the issues of AI. There has been quite a number of submissions that have been made by various countries in respect of AI, the challenges of AI and intellectual property, and these continue to happen up to date. And if you look at the issues that have been if you look at, well, I look at, let me rather say, the issues that have been raised by the various countries and various authors and experts in the field, in my opinion, they revolve around three main issues. The first being, what IP rights should be granted to artificial intelligence? And as Professor has mentioned, one of the issues is the issues of inventorship. The other issue relates to the issue of ownership. Can AI actually own intellectual property? The second issue is the use of traditional IP rights, such as patents, copyrights, and trademarks, to protect IP that is generated by AI. And if so, what are the requirements that need to be met? The last issue then is, can AI have liability? Can AI infringe, and can it be held liable for the infringement of others' IP rights, etc.? For the purposes of this talk, I do not want to focus on the second point, for the mere fact that there has been several guidelines that have been published by various countries like the UK, the US, as well as the EPO, in respect of how to deal with applications that relate to AI-related inventions. So I'm just going to focus on the first and the last point. So in summary, the points that we're going to be looking at is the issue of creatorship. So whether it's inventorship or creatorship or authorship in terms of copyright law. We're also going to briefly look at ownership, infringement and liability, which are actually quite linked. But before we do that, I'd like us to take a step back and ask the question, if AI creates, right? So if AI comes up with a story, so you're a university student and you have a submission to come up with an essay, and you use AI to actually generate that essay. Is that actually creation? And why is this question important? This question is important because from an intellectual property perspective, intellectual property relates to any creation of the mind. So for us, before we can try and apply intellectual property laws to AI-generated output, we have to first ask the question, does it actually cover AI-generated output? There is quite a number of proponents of the fact that AI actually does not create. And from the very same article that I cited earlier, they made a submission that even though it might seem exciting that you can create a piece of art, a painting or a drawing from AI, AI cannot conjure up new material from the ether. What they argue is that AI is trained on an enormous amount of data called data lakes. I'm not an AI expert, so if I use the wrong terminology, please excuse me. So they get trained on an enormous amount of data, and they also learn to actually acquire data and learn from it. And for this purpose, AI is actually not creating. It's just taking the data on which it's trained, creates rules or patterns, and then from that, then it creates predictions, or it makes judgments, and it creates some output. While this may seem to be very tempting, right, to dismiss the creativity of artificial intelligence, I would argue that this process is no different from the process that is followed by human beings in coming up with creations. Maybe there are people that are very creative, that are very imaginative, that actually can create something out of nothing. But for the majority, we rely on inspiration from other people, from people that came before us, we rely on inspiration from nature, from cultures, etc., in order to come up with creativity. The distinction is how different is what we come up with versus what already exists. And I would argue that the same should actually be applied in respect of artificial intelligence. So I'm going to move on the premise that it actually is the creation of the mind. And if you look to the patent law, for instance, patent law actually recognizes that for inventors to come up with new inventions, they do have regard to knowledge that is already available in the public. And hence there's a test for non-obviousness, which looks at taking into consideration what is known in the art. Has this person come up with something that is new? And patent law would even go to the extent of a party can, or an inventor can come up with an invention based on taking component A that is already known in the art and component B that is already known in the art, and put them together to come up with something that is new, that has a new technical effect, and you can get a patent granted for that. So the issue of creatorship can actually be attributed to AI, I would argue. So if we move on with that on that basis, then we can then move to the issue of creatorship. And from a patent perspective, then we would look at who is the inventor. And Professor Jolie has covered this in quite a lot of detail. But from a copyright perspective, we have to look at the issue of who becomes the author, who is the author. And why is this important? Because in terms of copyright law, the author is the first owner of copyright. And they would, if they wish, they would then assign it to the actual owner. But this is not necessarily relevant in other forms of IP law, like trademark registration. And if that is the case, then should can artificial intelligence then be an inventor? And the second part is inventorship or authorship a substantive consideration for the prosecution in granting of a patent or validity of copyright? And as Professor has mentioned, we believe that it actually is part of one of the considerations that need to be taken into account when determining whether a patent can be granted or not. In terms of our law, I would argue that it actually is part of the formal requirements that needs to be met. And the fact that we do not perform substantive examinations should not have allowed the patent to be granted. So I quoted the same section 27.1, and on that basis argue that we actually can infer that from the South African Patents Act that an inventor actually should be a human being. But we do not have a positive definition that says that AI actually can be regarded as an inventor. So I'm going to skip through the next 3 or 4 slides. The only thing that I do want to mention in this case is that my apologies for this. I just want to go to so I just wanted to just point out the fact that based on the Davis saga or the Davis matter, that matter should not be taken as a precedent in terms of how to deal with inventorship when it comes to South African law, because of the issues that Professor has raised. This issue still needs to be clarified, and we need a positive law a positive provision that actually identifies AI as an inventor or not. So with that, we can move to the South African copyright law. So in terms of the copyright law, copyright comes into existence once the copyrightable work has actually come into effect. And that is one of the determination of whether copyright exists or not. But the determination of the author is very important as part of the determination of the existence of copyright law. And this is important, as I mentioned earlier, because the author is generally the first owner of a copyright. There are some sections that make an exception to that rule, but just as a general rule, the author is the first owner of a copyright. In terms of Section 1.1 of the Copyright Act, it defines the author in respect of various types of copyrightable material. But I thought I would pick these two because I think these are very important, especially in the case of artificial intelligence. And the first section says, insofar as literary, dramatic, and musical and artistic work, which is most of the stuff that we are dealing with from an AI perspective, the person who first makes or creates the work is actually the owner or is the author. However, it goes on to further say, in relation to the same category of work or a computer program which is computer generated, the author is the person by whom the arrangements necessary for the creation of the work were undertaken. In other words, the developer, or if there is an executive developer who causes that work to be done using a computer-generated system, then that person becomes the author. So if you go back to what Professor was saying, is that if there is a person who prompts the AI to actually create something, in terms of copyright law, if we were to apply this section to the copyrightable work, then AI cannot be named as an author, but the person who actually prompts the AI to create that specific work should actually be named as the author. There is an argument that the current law is broad enough to cover this type of computer-generated work. And as a result, this can be deemed to exclude the AI itself as an author. So I look forward to engaging further on this. But looking further at the issue of Taylor, he did not just stop at patents. He actually, in the US, filed a copyright in respect of visual work, and he claimed that his AI actually autonomously created this work. And he argued that actually you do not require human authorship for the Copyright Act, and this was thrown out by the Federal District Court, and it held that actually human authorship is an essential part of that copyright claim. And it reasoned that only humans need copyright as an incentive to create artworks. As it stands, this is a decision of the federal court, and Taylor has actually indicated that he will be appealing this case. So I was not able to determine if actually this matter has been taken on appeal, but it would be interesting to see how the judgment comes out in appeal. So in summary, where we stand, and in line with what Professor has mentioned, AI is not yet recognized as a creator, or to have the same human, the same level of creatorship as natural persons, especially for purposes of formal IP rights. And this is largely still limited to natural persons. The case from South Africa is not authoritative enough to serve as a precedent in this case. What we do require are positive provisions that either identify AI or include AI as an inventor or a creator. When we move to the issue of ownership, the question then gets asked that can AI actually own IP or IP rights? While it can be argued that actually it should be able to own IP or IP rights, IP rights are an exclusionary form of rights. And the purpose of IP rights is to actually incentivize the creators of IP or inventions to be able to carry out inventions, to create, to come up with, to innovate, in order for there to be progression in the technical sphere and the artistic sphere. And as it was argued by the court in the US in the case of Taylor, it is not clear that AI actually requires an incentive to be able to create. And secondly, AI currently has no legal ownership, unless if there are some jurisdictions that actually have granted AI a legal personality. And in that regard, it becomes difficult to then be able to assign the right to ownership to AI. The third consideration would be then, if AI is afforded ownership rights, the opposite question should be asked then, whether AI can be held liable for infringement or for any other damage that may be suffered by third parties following its action. And I would argue that we should not rush, in as much as it is appealing to us to, yes, no, we can grant AI ownership rights. I would argue that we should not rush to agree to that question in the affirmative without considering the flip side of it. And I will deal with this question later. So, as I mentioned earlier on, the key concern from those in the space is based on the fact that AI uses large amounts of data to get trained and to train itself and to learn. And the issue is that some of these words can actually be copyrighted words. And when AI uses these words without the permission of the authors or the owners of those works, that can pose a risk for copyright infringement. And how do we deal with that? Who do we hold liable for infringement? In terms of the Patents Act, infringement occurs if a third party carries out the patented invention without the authority of the patentee. In the Copyright Act, if another person carries out or uses the copyrighted work without the permission of the copyright holder. And in copyright, it is not sufficient that you can argue, okay, but I only use like 30% of the copyrighted work. It's not as simple as that. So it is both a qualitative and a quantitative assessment that gets looked at. So if you copy, let's say you copy a painting by a famous painter, and you only copy 10% of that, but that 10% that you copy is the core distinguishing factor around the originality of that painter's work, then that can actually be viewed as copyright infringement because of the substantive nature of, or the substantive value of that little portion. So we will have to grapple with these issues, right, when we look at infringement by AI. That the fact that AI goes out and gets this data, this pool, and then comes up with something seemingly new, is that infringement? Or, on the opposite side, if it does come up with something new, is that really new, right? So if you copy, I don't know, Picasso's drawing, let's say AI goes out and it gets trained on Picasso's artwork, and it's able to figure out the patterns and I don't know, the methodology, let's say, that Picasso would use, and then it creates a completely new piece of work. But when you look at it stylistically, it's similar to what Picasso would do. Is that infringement, or is that an original piece of work? And that is one of the major questions that we're going to have to deal with when looking at the creativity of AI and whether it can be held liable. And I think in the same manner that there are certain aspects that are excluded from infringement, the same should actually be afforded to AI. So if there is infringement, then who gets liable? We can say that AI should be held liable, right? Because then it lets a whole lot of people get away with a whole lot of things, right? But the problem with that is that it becomes very difficult to then enforce it, because AI has no legal personality as we stand. So it becomes very difficult to enforce it. Who are you exactly going to enforce it against? Right. And currently, AI is a tool. So behind the AI, there is a developer who inputs data or who inputs principles, right, that then inform how the AI behaves. I think they're called heuristics. Did I get it right? Right? So the developer inputs a set of principles. So in as much as AI has the ability to learn, its behavior is based on a set of principles that are usually put by the developers, and that's why the issue around biases, potential biases that actually can be introduced into AI, and that can lead into undesirable behavior. But not only that, at the point where we are in terms of the development of AI at this point, it still relies on prompts from an external user, whether it's a single instruction or whether it's a set of instructions that get inputted. It still relies on that for it to be able to perform the functions that it does. So in as much as we would like to hold it liable, there is still some input from human actors or human agents in that respect, or human principles in that respect. And for that reason, at the point where we are in respect of the development of AI, my argument would be that the developers and/or companies that hire these developers should actually be held liable in the case that there is any infringement of copyright by AI. In summary, I think that there is a need, actually an urgent need to have certainty around creatorship and ownership insofar as it relates to AI. And when I thought about it, I think one of the key considerations that will need to be really thought through is the legal personality that is afforded to AI. I think if this fundamental question can be answered at this very point, that will take care of maybe 30%. I'm not being very optimistic. Maybe 30% of the issues that we face around AI. With obviously the appreciation that it may well be that in 50 years' time, maybe 30 years' time, AI would have actually developed to the point that it can have that absolute autonomy, right, that would afford it that right to have legal personality. And I'd like to thank you and end my presentation now.
Thanks very much for that presentation, Ms. Mudibela. We are now going to ask our last speaker, Dr. Ndani, to come to the podium. A round of applause, please. Thanks. The presentation are tasted. So at least I succeeded in distracting and slowing down myself in the process. It was not part of the plan. So what I did in the mornings, I sent him version 1 prior to go to breakfast. And intentionally to go to breakfast, if I think about something, come back and go provide him a version 2. Unfortunately, we did not recognize the version 2 part. Thank you very much. It's a real pleasure to be here. My first time in the University of Limpopo, and I was quite excited to be back home.
Colleagues, can we kindly settle down just to allow the speaker to speak? Please.
Right, yeah, as I was saying, I'm quite excited to be back home in my home province and to chat about some of this important work that we deal with as a country. I think also from the practice of technology and also from the scholarly work as well of technology and innovation. I think I'll start off by making some reflections from a global divide point of view. This work comes from UNCTAD, the United Nations Conference on Trade and Development. And really what the sketch shows is just the divide over the years as the proliferation of technology happened and concentrated largely around the global north, what the report terms at the core, versus at the periphery, and what happened from a real GDP point of view over there. Because we are ultimately talking about one of the central technology of the fourth industrial revolution. I think it's important to reflect on what the journey of technology and overall the revolutions themselves, which have been a guiding piece of that work. And what we see up to now in terms of the space of the 4IR is this separation that has happened over the years. And I think some of the speakers have spoken about earlier in terms of what the separation that has emerged in other parts of the world where the technologies are used based on how they are trained. And I think on this particular point, I do want to reflect on one quote that I had in 2019 while I was attending a conference in Pretoria on innovation for inclusive industrialization. And one of the closing speakers said, by themselves, innovation and technology are not essentially inclusive. They are not born inclusive. You actually have to have ways on how to help them to be inclusive. By themselves, they continue to do what they do if you do not have anything that you can do. I think the next piece of this work is, the UNCTAD calls emerging technologies frontier technologies, and part of the work that they've done is to look at the readiness. And what you can observe is that our readiness as the emerging economies, as the developing economies, seems to be on the lower end. So our ability to harness, our ability to develop, our ability to deploy and diffuse these technologies appears to be below the world average. And I think lastly is the aspect around skills when one looks at the global divide. So this is not just happening by itself. There is an element of skill to develop and drive these complex technologies. It requires your skills profiles to be at a certain level for you to be able to achieve. And I think it's quite important that we are here today at a center of things so that we are able to upgrade our skills and position ourselves for technologies that it interfaces with, that it contributes towards. And here's just a range of frontier technologies that UNCTAD makes a record on. First, from an Industry 4.0 perspective with artificial intelligence right at the top, followed by Internet of Things. And also in view of the sustainability work, the sustainability transition that we find ourselves in, also from the perspective of green frontier technologies. And then lastly, on the far end, which AI also plays a great role around nanotechnologies and gene editing. I think there's a lot of work happening around health, where artificial intelligence is being utilized to make quite a number of improvements. And of course, there are questions. I think one of the things when Ompile was concluding around us not rushing, I made a note about policy and intended consequences. So while it might be exciting to make a rush in some of these things, but from a policy point of view, there are unintended consequences. And if we don't wrap our head around some of those things, we will be excited to move, but yet find ourselves that we have created issues that we find ourselves now not being able to manage. And I think secondly, when one makes a reflections on the frontier tech, and I love this slide from the perspective that as much as a lot of the conversation hinges around artificial intelligence, from a market point of view, the prediction and the argument is actually that it is the Internet of Things that actually dominates from a market point of view. And it actually makes sense because in this digital world, it's about sensors, it's about sensing, it's about digital economy. I think technology and these technologies and how we develop them, how we manage them, happens to follow certain patterns. And I think the first thing to reflect on is this element of innovation drivers. Are we dealing with a technology push, or are we dealing with a technology pull, a market pull, or is it a combination? Are we simply just
pushing and shoving a technology into the market, or there's actually a market that is pulling this particular technology in, or is it a balance of those forces that we then trying to do? Because it then becomes important in terms of how do you then develop this particular technology to meet these pathways that have actually emerged. And I think as much as the technology itself already exists, the notion of emerging technologies is that they themselves are emerging. They are not done. They are only in the beginning stages, which also highlights that there are enough opportunities for us to participate in ways that make sense for ourselves. I think the second aspect as well, and this work has been growing some popularity now at the nation, is when you use AI to simplify certain products in a manner that you make them available to either overshoot customers or to non-consumers. An example of overshoot customers is consumers who are frustrated by products that have got upgrades and upgrades that they don't use, right? I'll use Haval and Hyundai and Kia as examples in the automobile space where organizations simplify products, put hatchbacks, put sunroofs, and make a product that still makes sense, much cheaper than your BMW and your own. So in that instance, you will make an investment around innovation to simplify products and make them available to those consumers. And then on the aspect of non-consumers, it is those who precisely are not able to consume a particular product. I always make this example in my lecturing work at the Business School Innovation, that when someone doesn't have electricity, and you develop a solution that gives them electricity for 6 hours, they will be satisfied that now they have electricity for 6 hours versus no electricity. So those consumers, we actually call them non-consumers as it stands. So in that instance, we are creating AI models that are trying to expand the market, are trying to broaden and make sure that there is more accessibility. And I think when we make our reflections about artificial intelligence, these decisions are important, because otherwise if all we are doing from an artificial intelligence point of view is on the efficiency and the sustaining side, there's a lot of room in terms of you ought to place this particular aspect. Otherwise then you'll find someone trying to make decisions with a model that is trained for a particular application outside of that. And I think this is where some of these issues emerge, because you're actually trying to deploy a particular technology, because ultimately it's a technology. And fundamentally, from an engineering perspective, a technology is a technology envelope. That's got a boundary. It can only do so much, right? And that's why in terms of making this conclusion around the technology itself, I like these few analogies around, aircraft fly, right? Ships sail and cars drive. So the reality is, especially when one goes back maybe to the unsupervised and the reinforcement, there could be spaces where AI learns things that we obviously don't know, and it's bound to do things that we don't know, right? But the very same principle on how we design a nuclear reactor applies right here to artificial intelligence. That you as the designer, and I like this conversation around who owns it, you as the designer has the responsibility to make sure that your system is designed in such a manner that when there is a runaway reaction, you are able to contain it. Right? Otherwise, then we are running into a lot in terms of guiding us and helping us to make sure that we always import and adaptation. There are capabilities and infrastructure requirements. You cannot move a technology from TRL, the technology readiness level 1, if I'm to borrow the NASA specification, up to TRL 9 without certain capabilities and infrastructure. And if we want to then participate from an artificial intelligence point of view, are we aware of the capabilities and infrastructure that the technology needs to move from where it is to the other end? And of course, as the earlier speakers, and I think even from the start during the introduction, as a country through the Fourth Industrial Revolution Commission, we made certain commitments around the need to have these infrastructures in place, and that as a country, certain investments have to be made. We cannot continuously wish for certain technologies to be part of our economy. There are investments that we need to make. It's like as a student, you can't wish you want a PhD, but then you don't engage in the pursuit for an actual PhD. And I think the very same principle applies from technology leadership perspective. And I think once the decision has been made, and if it is a combination, there is an element of trade-offs. You saw that range of emerging tech. Odds are you're not going to be a leader in all of them. So which technologies do you want to be a leader at? Which ones are you going to partner with others? And when you decide to do the partnership, who then becomes a partner for you? And I think then the next aspect is around prioritization. And another piece around technology is about pace, right? Because at each moment, there is always a window of opportunity. Right? And these revolutions are in themselves windows of opportunities. They come and they go. So if you don't make certain investment within a particular window, odds are you are going to be left behind. And I think part of where we are now in this constellation where everyone is figuring out what must happen, what mustn't happen, at some point, the understanding of these technologies is going to be established. And what you had there as a list of emerging tech will not be emerging tech anymore. There will be a new list. And if we are still trying to scramble with the previous emerging tech, when others have moved on, the reality is we are going to find ourselves pretty much behind. And I think lastly for me, and I like part of the conversation that Ompele touched on, this process has an element of experimentation. There's a lot of things that we don't know about what will work and what will not work. And I think in the same way where there is experimentation on the technology front, there will need to be experimentation also on the policy side. I think South Africa is gearing up a lot more now around policy experimentation, because some of these things have to be experimented prior to us being able to do that. But I think right at the bottom of this is there's an element of investment and data availability. I think the previous speakers have highlighted about the need for these technologies to be trained. So that data has to be available somewhere and has to be approved that you can use that data, with issues of privacy and a whole host of other things. And for that data to be available, storage is important. The question is, where are we storing it, and who's owning that data that is being stored? I think the Minister of Digital Communications and Digital Technologies recently issued version 2 of the National Data and Cloud Policy. And part of what the National Data and Cloud Policy advocates for is around the ownership, the monetization around the data that is local, dealing with issues of privacy and all sorts of those things. And you cannot ignore those aspects when it comes to storage. And then there's an element of investment. There is no innovation in technology without investment. You cannot think you're going to lead in certain technology areas, because it's about competition. Others, you need to put money to drive pace and directionality. If you don't have the investment to do that, then you're going to have to take what others produce. And then, as I said, the aspect of emergence means that there are a lot of unknowns. There are risks, both on the technology front and the impact on the consumers and the society. And the question, how do you manage those risks and also the unknowns? And I don't highlight this particular aspect for us to run away. It is to gain the competency to understand how to navigate all of these things. And I think lastly, at the far end, and this is where perhaps the bigger part of the investment comes in, is really how do we distribute now these technologies that we've put together in the TTOs, in the labs, and widen their adoptions across society. And even that in itself is an investment. And I think we always just think the technologies are just going to move by themselves. Just like knowledge, just because it's a university here, it doesn't just flow to the next one. There has to be effort to move, to bring the locals in to study here, to send them back to society. In the same way, once we have developed the emerging and amazing technologies, there has to be an investment around the distribution so that those technologies and the gains associated with them are then taken to market. And I think the last thing on the experimentation piece, and I think I read something during the week, again on preferential procurement, is an aspect of market access. When a technology is done from a technology point of view at a TTO or any other place like the CSIR, it has to be used for us to see how it actually works. And a big challenge that we have now here in the country is that as a country we can make an investment in a nice technology. When it works, whichever entity that has put it together has to go through competitive bidding. So we go through all the efforts of spending, I think the government now spends about 15 billion per annum on R&D. When we've done that, if someone smart from the university comes up with an idea and takes it ready for market, the state itself has to allow that person to compete while it should just be procuring it and getting it to market so that it can actually get to work. There's an interesting policy space that has been debated on to try and drive the uptake of local innovation as well. And I think, just in terms of conclusion, with this, I didn't get into the aspect of the human rights. But I think what we see is that this technology has emerged and everyone, there's a lot of fear around the technology, around what it's going to do from an intellectual property point of view. But I think the reality of it being emerging is that there's perhaps things in the past that have not considered it. Just like there will be other things even in the future. So while today we are contesting around artificial intelligence, there will always be moments like this where there's contestation that perhaps how we have prepared something was not done like that in the past. I can think about, a good example. I'm sure in the early 1900s when the first vehicles came into the road, there was no speed limit, right? It just did not exist, right? So in the same way as we engage and we are in the frontier of technology, there will be things that we as society have just not thought about, whether it's on intellectual property, whether it is on human rights. And the question must not be, have we made mistakes? No, we just have not thought about it. Can we now sit down in the view of what we now know and think about it and make the decisions around the consideration or not the consideration? Right? And with that, I'll say thank you very much.
Thank you very much. Maybe before we move to the fourth item, which deals with questions and answers, can we check with our audio people if the sound is proper online? Because the last time we checked, our colleagues were not happy with the sound. Maybe before I call upon the moderators to come and lead the conversation, I would like to recognize Mr. Singh from the LPC, who's here with us. Thank you for joining us. I would also like to recognize our colleagues from the University of Northwest in the Department of Mercantile Law, and also our colleagues in the University of Free State who are with us in the Department of Mercantile Law. With that said, colleagues, allow me to call upon the moderator, Mr. Leveno, joined by Mr. Ngwani, to come and lead the discussion. Okay, colleagues, this is how it's going to unfold. We are going to allow our moderators to pose some question or give some reflection, and then from there we'll also allow colleagues from the floor to also pose questions or give comments. We shall move on to the first one. Very kindly.
Thank you, colleagues. As I was listening here and looking at the presentations by the speakers, and then thinking about machines, and you bear with me, I grew up in the era when you was Terminator. And when you were looking at Terminator, you then think about machines taking over. And that's the narrative probably that one should maybe probably think about. And as we look at the ability of machines to learn and to change things and to harness knowledge from across the internet and all that, one then thinks about the use of that knowledge for civilian use, and rightfully so, you can develop things, you can change things, you can be innovative. But there's also one thought about, from another aspect, the military side of it. The use of machines in the military. What are the detriments thereof? And I'd like to pose this question to the colleagues and say, have colleagues ever thought about the use of machines, learning and things, militarily? Imagine if, for example, a machine somewhere can connect to other machines in other countries and release nuclear weapons. What would be then? What would be the net of us as human beings? Thank you.
I think Mr. Ngwele can go ahead, then from there we'll allow the response.
Thank you so much, Program Director. Colleagues would have seen on the program that I am referred to as Mwenya. That was a closely guarded nickname at the school. It somehow made its way to the printers. My surname is Mwanya. Thank you to our panelists for the interesting discussion. The intersection on artificial intelligence, IT, and human rights. My question, and perhaps as part of the discussion, relates to telemarketers. I'm sure all of us must have received telephone calls trying to sell you something, and this ties down to the discussion and the presentation around information that we feed or give to the banks. When we buy licenses and upload programs on the computers, it asks you for your ID number, it asks you for your address, and we do not know where it goes. After the presentation, we know that it goes somewhere and it is referred to as big data. It is processed and ultimately it is sold by what is referred to as data miners. My question then becomes, from an enforcement perspective, what strides has South Africa made? We have got the information regulator. We must have seen in the news there's an enforcement notice around telemarketers, which have now taken it a step further. You do not get a person calling you, but you get a computer that calls you. Good day, how are you? And if you answer and say, who are you? It says, good day, how are you? To show that it is actually AI calling you. What enforcement strides have we made as a country to counter that, because it turns to issues of privacy? I think let me pause. Thank you.
Thank you, Fred. Can we have our speakers aid just to reflect on those comments?
I think I'll take a step around the military part, and then I'll leave my colleagues to attend the regulation part. I've not been following what the information regulator is doing and how well it's doing it. I think what's key, from I mean, the earliest days of any form of fighting, technology has been a core part, even if it was a sport, but always a form of technology. Spears, I mean, even when the aeroplane came, that was a form of technology that those who could harness the technologies at the forefront at the time could then be in the forefront in terms of the battle. I think the reality even today is that the new technology now is around artificial intelligence. Those who will make the right investments are going to be in the forefront. And they will manage those technologies in a manner that allows them to be in the forefront. I think we have seen the US around TikTok, even though it's a technical security decision. And I think the question on our end is, how do we then have engagements around that? I think when we were about halfway through the FOIA commission, there was a session that we actually held, and there were some members from the South African Defense Force, where they were also highlighting that there are certain things that they are not yet thinking about, because where is the military base now, where is the war actually taking place now? It's not at the same place as it was in the past. And the question is, if you're not making the necessary adaptations and investments, we might be thinking here saying that we've got a national defense force, but actually it's a defense force that cannot protect us anymore.
Thank you for that.
Thanks. I think I'll continue on that discussion about warfare and the deployment of AI. I think going back to my discussion earlier on about human rights, I think the discussion of AI being used to create weapons of mass destruction, I think is one of the aspects that one should consider. Think of this hypothesis. You go into war, your opponent is using completely automated weapons, and your opponent is indiscriminately killing civilians, indiscriminately targeting places because of this AI's ability, So I think from a human rights perspective, one should consider the pros and cons of AI deployment in warfare. I've been following what's happening in Israel and Gaza. If you look at some of the defensive capabilities that Israel is using in order to ward off attacks, those would not be able without artificial intelligence to some extent, right? For there to be a system that is constantly monitoring the skies for attacks and stuff, it means there is some algorithm that's taking place there. So I think there are benefits of using AI in warfare, and I think there are also serious human rights considerations that one needs to think about in the art of war and the rules of war. I think I'll leave it at that.
Thank you, Prof.
I just want to comment also quickly on the issue of weapons and AI. Taking the issue from a patent law perspective, we say when we look at the patent laws of all countries, each country actually is given the leeway to legislate in a manner that's in the national interest. So it is possible for a country to have, there's an aspect in patent law which Americans call beneficiary utility, where we say an invention may be denied on the basis that the results are unacceptable. So we are simply saying in this particular instance, in the national interest, it's possible some countries can say in the interpret the inventions in that sphere are totally outborn. But in South Africa, there is a specific provision that actually gives room for the Department of Defense to patents and they actually inquire into whether they can be accepted or not accepted. So we are saying it's not a wide open thing that you can invent. Just give you an example. One invention, I think it was a gun that was, I can't remember, but last year, I know that invention was accepted for display. This gun is a gun that uses materials that were not dictated by metal detectors when you come in. So the owner of the invention is quite thrilled by that fact that, look, here I've come up with a gun. You said you want to get it. It's quite disheartening. Some countries actually have to do that. But I'm sure in South Africa, there's a provision for registrar to deny certain inventions, certain situations. But otherwise, without control, other controls outside the IP sphere, it does not.
I think my addition to everything that you have stated would be that technology exists within the realm or the confines of a society. And I think that consideration has to be made in respect of what will be permissible in South Africa and what will not. And to the extent that we're not able to enforce just locally, it means we need to consider international treaties that curb the potential use of technology to the total destruction of society. And I'm not but I think it's critical that we don't view AI as a tool that allows people to get away with things that an ordinary human being would not be able to. But at the same time, we recognize the potential that actually it does give people that ability to get away with things that other people would not be able to do. And build around AI the provisions in the law that allow us to either prevent those atrocities to happen, or to hold people, companies liable in the case that they do use it against that. And the point that you raise around the Patents Act, for instance, it's one that's is available. So there is a provision in the Act also that in the case that there is an invention or an application for an invention that has military application or that has nuclear application, it actually has to be referred to the Department of Mineral and Energy, and they would then have to make a decision in terms of whether that patent can be granted in South Africa or not. And I think we need to delve into understanding the potential harm that can be brought about by AI, the same way that we did when nuclear became a reality, that we had to take measures to make sure that we don't bring about the total destruction of humanity.
Thank you. Maybe let us afford the colleagues and our students from the floor. Or the second question.
Yes. As a subsequent intervention, deal with the market's problem.
Thank you. I've seen that there's been some movement by the information regulator in terms of, should I say, enforcing PIA and telemarketing. And I think just to bring it into the whole AI discussion, I think the prohibition within Section 69 of the PIA, specifically prohibits the use of automated electronic tools, right, to send unsolicited electronic mail. So the moment that some robot is talking to you on the phone that you don't know, right, you need to ask yourself two questions. Where did they get my number from? And number two, why is this robot talking to me? Why is there not a human being on the other side? And the reason for this prohibition, I think it was done solely for the reason that information of data subjects is not abused, and that we don't use modern technologies to bombard people with SMSs, bombard people with emails, and any other form of electronic technology. Thank you.
Okay, thanks for that. Can we now open the floor for questions, comments? going to note you. Yes, Professor Odip, you're number 1. Yes, ma'am, you're number 2. My brother, yes, you're number 3. Then my sister is number 4. Dr. VIC, let me take that student to number 5. Then Dr. V, you are going to be number 6. You are going to press in there and ask questions. Then once they respond, then we'll give you another chance for other colleagues. Let us start with number 1, Prof.
Yeah, thank you very much. I am very much aware that various advanced issues raised by the presenters, and as such, many people will want to ask 1 or 2 questions, so I will try as much as possible to be brief. Firstly, from the program itself, the aspect of artificial intelligence and intellectual property, well articulated and presented by presenters. I am limited in intellectual property. And what the second aspect, human rights, except for Professor Caesar, I did not come out clearly, strongly from the presenter, because we're talking about artificial intelligence. My question is, what about the aspect of universal access to internet, the core component of operationalization of AI? I did not hear anything about that. That is the universal access to internet. And the aspect of a space, we have all data stored in space. Everything about us is about space. Then I continue to ask the question, what happens if there's space conflict? To the extent that there could be everybody's flying rockets to the space where those things were stored. Tomorrow you can go to your bank and all the bank accounts will read 7. Where are my savings? So those are the questions that should agitate our minds in the era of AI. And lastly, so that I can give others an opportunity to talk, we are so intellectually parochial, including myself, that we only think about this technology as regards of elites, educated people. When we talk of discussion of AI, where are the people in the rural settings? What if AI should benefit mankind, which is supposed to be? Are we exposing them? Where is AI inclusivity? And why do we include others in the aspect of beneficiation? Thank you very much.
Chapter of number 2.
Good day, everyone. My name is Bantina. So, my question is directed to Professor Lonas Ndlovu and Ms. Okile Dibela. So, we know that for a human to be a human person, that human has to have a certain element such as mental capacity, So, how would we know that AI has sufficient capability so that we can accommodate it in order for it to have ownership rights, and so that it can be liable, like we can hold it liable for, infringement and other things?
Thank you, ma'am. Captured. Can we have the third speaker?
Yes, sir. Thank you, Manoj Dinga Washu. Before I make my comments, I want to sketch a broader background to technology in general, because we tend to think of technology in silos. But if you look back at where technology comes from, in a way, and I'm responding to the question about wars and warfare, technology emanates from the military industry. in the main. You talk about the internet, you talk about computers, you talk about microwaves, almost every groundbreaking technology emanates from the military. Now that tells a story about it being in the military. Because I'm looking at AI as it develops now in the world, and it's basically sketching the contours of power relations in the world as they are. So for example, America is leading, and deliberately, and then China is also trying to fight for its space. France came and they struggled and they fell off. The UK is now number 3 in the league. So what I'm saying to you is when we look at AI and we try to contextualize it in South African context and say how does, for example, it affect human rights, we tend to make a mistake of looking at it from a micro level. Because whatever gets invented in the US will have human rights implications in South Africa as well. Right? So if you talk about AI, we talk about it as if we are worried about what is going to be invented in our own country. And that is a myopic way of looking at it. Right? So that's number one. But the bigger issue for me when we talk about AI is to understand it beyond it being a technology. Because it is not. It's a geopolitical tool. It's an economic domination tool. So countries that want to dominate the world are throwing all the money they have at the development of AI. And in Africa, we're sitting back and waiting. I don't know what we want to do. Do we want to adopt other people's technologies? I don't know. But that logic beats me, because now you're sitting here, you're waiting for America to invent something. Do you think they're inventing it for you? No, they're not. And that is the problem with the continent for me. That's my biggest criticism of how Africa approached artificial intelligence. We have the PCI, the Presidential Commission on the Fourth Industrial Revolution. If you read the document that they produce, they are trying to contextualize our approach to technology in general. To South Africa, they're talking about unemployment, poverty, and inequality. It's well and good, but when you move on to the other documents, then there's a destroyed. So I'm saying South Africa, as a country, as is now my assessment, is all over the place when it comes to AI. And that bodes ill for us as a country, competing in the world. Thank you.
Is it captured? Okay, thank you, sir. Can we move quickly to number 5?
Okay. I'm Kenny. My simple is very straightforward and simple. And thank you for the opportunity. Where do I get access to these AIs and where do I find them? Where do I know about the requirements and their limitations?
Thank you, straightforward. I think it's captured. Doctor.
Okay, thank you so much. I wanted to just find out why is South Africa and Australia not authoritative enough in being used as the decision made as a precedence? Thank you.
Thank you. Can our colleagues reflect and give response? Is another hand? Oh. Okay, this is what we are going to, because we don't have time. I'm going to allow these 3 hands to go through. Ma'am, you go first. Then you'll be number 2, you'll be number 3, then you'll be number 4. 5, then we're closing, because we don't have time. Then from there, I'm going to allow our moderators the last bite, then our speakers the last bite. Can we shoot? Yes, ma'am.
Hello. My name is Jasmine. I just need some clarity on something for interest's sake. So I won't lie to say I don't know GPT. I do. And some of them has asked me for my details, right? Thing is, I never saw it in a way that, okay, my question is posed to Prof. Sizwe Snail. Yeah? So I I didn't look at it in that perspective that you mentioned in your presentation. How I viewed it was in a way that it, like you mentioned before, that it is a powerful tool, right? And we have witnessed how it has been developing, undergoing continued advancement from GPT-2 to 3 and 4 Pro, I think. I'm not sure. Yeah. Looking from how before, from 3 to 5 years back, it would provide very limited information or sometimes inaccurate or irrelevant information, right? Transitioning to how currently the information that it provides us with is very convincing. And the quality of it is good, right? Which is impressive, right? So isn't it a result of the database they've collected? Maybe I'm not understanding that. Another question is, isn't it one of the goals to develop AI to the levels where it provides personalized and relevant feedback? Yeah? So looking at it from the human rights infringement perspective, would you advise that when we, especially students or researchers, or people that use it for whatever purposes, would you advise that we rather use demo accounts, false emails and details? My question leads to Ms. Umpile. You mentioned the questions one or two of the questions you mentioned. I would like to pose it back to you to say, would you say that AI can infringe human rights, and if so, can it be held accountable for that infringement? Another thing I got to learn a few days back was that Microsoft has been working on some project where AI was learning how to discern between male and female. Good news was that at some point it was able to give accurate results. However, it would fail with black people, particularly black women. So the project was then sent to Africa, where the black people are dominant. I think it was Kenya, if I remember quite correctly. It was sent to African researchers to work on. Good news again was that it became more accurate, specifically to the black women, because that was the problem, right? But it was later discovered that it didn't quite know the difference, and that it only detected the correlation between makeup and women. So, for instance, the pink cheeks and the pink lips, yeah. So, because the researchers would, after it would say this is yes, it's a woman, the researchers would say yes, you're correct. The researchers would confirm that yes, you are correct, it is a woman, right?
Sorry, colleagues, can we settle down? Ma'am, you see, we don't want to have police the debate. We understand that this is a learning environment and a learning space. But can you kindly, we humbly request, just wrap it up so that we allow others to just...
Okay, long story short, straight to my question. So,
colleagues, can we allow a space so that you...
So from that, and together with your presentation, I would like to know, would you say that those researchers were, the researchers and the scientists were in the process of infringing those humans' rights, the right to equality? If it were to be finalized or be accepted or be produced, would you say our rights will be infringed? May you please get me through that. Thank you.
Thank you, ma'am, for that. I think it's captured. Can we swiftly move to number 2? Colleagues, I know that some of you might have some bit of knowledge about this thing of AI and so on and so forth. We just humbly request, let us go straight to the point. Yes, number 2, can you just shoot straight to the point?
Good afternoon to the panel and my colleagues at large. My name is Brian, and I just have a simple straightforward question of, since you've been presenting on moving into the industrial revolution and adjusting to utilizing AI and so on and so forth, I have the question of how do we ensure that AI aligns with the human values and ethics, given that the diversity of those values across different cultures and societies, while preventing harm as we dwell into the fact that we are supposed to be using this in that's called the AI. Thank you.
Thank you, Captain. Can we move to number 3?
Okay, questions to members at large. I only have 3 questions. My first one is that with AI that is replacing, like the robots, is replacing people based on where are the people going to work, whereas the robots are taking the responsibilities that people are supposed to be doing. The second one, I want to know the penalties of using AI in research and not implementing it. Will I be penalized?
Something that I was just bypassing on. The issue that I want to speak of as our topic relates that the seminar on the intersection between artificial intelligence, intellectual property, and human rights. So you've done well, my professors, when it comes to the artificial intelligence, intellectual property. That was nicely presented. But there's this other portion that I feel it's what you call it's lacking behind the human rights. My question is basically directed to Snail Gamtuze to say, based on the issue of the founder of this thing, you said there's somebody who presented this thing, John Macaulay, you'll correct me somewhere if I'm wrong, to say he founded this thing in the 1956, what you call times. So this thing, it's old, it was there. But my question is, what is your preference between the machinery thing or the AI and the Constitution? And I'm also going to what you call to include your colleagues, because they also were touching on the section 27 of the Constitution, section 25, section 16, the what you call the freedom of expression. So it might happen that in today's political spectrum, we are sort of speaking or talking for the sake of talking. My question is, this wonderful right, section 16, where everybody's free to speak, where was it all along up until today, as our nation is what you call is confronted with the challenge? Everybody knows. And if the right was inexistent for us, why were we not free to speak? And are we really free to speak in totality? Because the injustice of the past is still the injustice of today. The haves and the have-nots, those that are in power or bias, somebody spoke of that. Even in our institution, we have people who are biased. I don't want to go there. But I'm saying this is a sickness or a disease or an infirmity that is what we call covering and shielding our continent Africa. So everybody is from the poor background. If I'm entitled with this power, with this power to what you call to lead, the first thing that I'm going to do, I'm going to take whatever I can into my pockets and my community, if we say not my community, my family, and make it a point that everybody is sorted before I can take care of others. Then we now say, you are somehow applying injustice, we don't want you again. That person is already fed. And then the one who's going to come in is going to be, yeah, somebody doesn't want me to speak. Okay, finally, let me not go deeper on that one. Those who had me. Only rose amongst the thorn. So you touched on something about the liability and the infringement.
Sorry. Can colleagues, can we refrain from disturbing? I see there's someone who's still tampering with the mics, please. Can we refrain from that? Ma'am, can you?
That's my last question. I've taken much. I'm sorry, problem direct. The lady spoke of the liability part. So my input there is that AI is recognized, but it cannot be liable when it comes to what humans critique in terms of liability. AI cannot, because AI is what we call is fed by human beings. So whatever information that is there is fed by human beings. So it cannot take the status of standing on its own. My question is, who is to amend and when to amend the Roman Dutch law or the common law, which was imposed on us? Because in terms of Africanism, who stated that somebody said, if I go behind the prophet and what is part of what I believe in. I'm an African woman and I believe in my ancestors. So my ancestors are there to guide me as to when to see them. My apologies. I do want to do that, but we are running out of time, colleagues. Now, this is what is going to happen. We are going to start from Prof. Slade, whatever reflection, whatever that you want to say. Just choose them. Yes, and can you, I know it might not be practical, can you, if possible, in 3 if not 4 minutes, if possible, then you deal with that and then we'll move in that sequence up until Ms. Upino. Can you do that? Okay, thank you.
Thank you, Program Director. I think I want to start with the dear professor at the top there, who had the question regarding access to information and the have-nots and the haves and the digital divide and the implications of the Constitution. Now, one can only say so much in 30 minutes. That's the first thing that I want to say to you, right? I'm actually one of the proponents of access to information and access to information in the context of the internet and the proliferation of internet access, be it in rural communities, be it in the ghettos. So the whole discussion around human rights and access, and AI, I think it's a discussion which should have its own conference, right? I think the idea of the conference organizers was to talk about the intersection. I think the intersection is the catchword there. And yes, there are intersections of privacy, there are intersections of freedom of expression, I mentioned social economic rights. There are so many rights in terms of the human rights that we can intersect. So if the dear professor would like to have a chat with me after this, I would gladly have an hour chat with you, Prof. Then, with regards to the aspect of AI sovereignty, if I understood it correctly, because I tried to bring them down to, some of the questions were a bit long. I think AI sovereignty is a concept that states all around the world are worried about. What exactly do we understand under AI sovereignty? It is a nation's ability to harness its own technologies, develop its own technologies, and use same, be it for defensive capabilities or even military capabilities. If you look at some of the strategic documents drafted by the AU on AI in Africa, the aspect of AI sovereignty is being underscored. We are being told to less copy and mimic for what is done in other jurisdictions, and we are being encouraged to develop our own AI technologies, right? He who brings the AI technology is in control. It's not a fallacy, it's just like that, So I think in terms of AI sovereignty, I think that is a policy issue which our government, I hope my former colleagues from the Department of Communications are here, I hope that they look at that from a policy perspective to see how AI sovereignty can be dealt with. Then there was one question about anonymity, right? And the usage or the ethical or unethical use of ChatGPT in academic use. Yeah, well, somewhere here. I would strongly recommend those dear students to stay away from ChatGPT, right? If they intend to want to graduate from this beautiful university. Because should you be caught having used ChatGPT in your academic assessments or any of your work, and I don't want to step into the realm of my dear IP colleagues, you could be guilty of plagiarism or you could be guilty of copyright infringement, okay? Then there was the issue of AI and labor. Unfortunately, I can't take that matter further, yeah? Then there was AI and the practice. I specifically did not want to talk about State versus Aliyu. I specifically didn't want to talk about Forsyth versus Parker. These were all the cases where our courts actually made decisions on the use of AI, and this then also tags on the question of reliability, right? This is where attorneys used AI to cite cases, and it turned out the cases don't exist. So those attorneys got nailed, full stop. So if you as a practicing attorney in the future want to rely on AI to do legal research, please go read Parker versus Forsyth and the consequences of that. And then the last question that I'll answer, like I said, was a lot of questions, is the question of vicarious liability and AI, right? He or she or it who develops AI is responsible for the consequences of its deployment, right? This is the beautiful aspect and the ubiquitous nature of our law, right? The Roman Dutch law on vicarious liability, as you so eloquently put it, it makes it very clear that he or she who is guilty or is responsible for a delict to a third party, that person, if there's sufficient causation, and like I said, I'm a lawyer, I can talk all day, right? Then you can impute criminal liability to that. Program Director, thank you.
Thank you, Prof.
You're supposed to measure him. Exactly, and say stop. All right, now I'll touch on like 3 things and then close. I think on the aspect of plagiarism, so at the University of Johannesburg, I know they've put together some rules around the use of AI tools such as ChatGPT, so students can use up to a point. So I'm not sure what the status of the University of Limpopo, but I think you can't completely ban these things. I think you need to figure out how you introduce them in a manner that helps the students to achieve certain things, and it must be guided. So I think the people of the school can make a reflection on where they are on that, and perhaps learn from other universities as well. The issue of employment. So the reality is, if you are purely making use of technologies from other people and you're not involved in the actual value chains of those technologies tend to be employment eroding, which means as they come in, you're not having any backward or forward integration. So the reality is you are just purely importing the final use into the economy, and then the intensity and the complexity of your economy is quite small, which has limitations. But I think the issue of employment, as you bring in new technologies, will happen, but the question is, if you are involved in the value chain, it speaks to the aspect of investment. I mean, our R&D investment, and I know R&D is not full innovation, it's only a proxy. I mean, it's hovering around 0.6% of GDP, while our target is 1.5%, for as long as we have made that decision. And no one has been arrested for why that R&D investment is not at 1.5%. While we know very well that other countries who have made investment as high as 2 to 3% of GDP have made progress. And one of the points I've brought up in some of the engagements now from a monitoring and evaluation point of view is when we place national targets like this, how do we make sure that the government accounts for targets that it has put together? Otherwise, targets remain targets and we're not actually doing anything about it. So I think there's something to think about there in terms of how we are in the 7th administration. How do we monitor the state on its commitment within its administration and not wait to the end? The last thing is really on the training of the AI models. These things need to be trained with data that makes sense for what we're doing. And I think there's a lot of work happening in the University of Pretoria through Professor Marivat and perhaps when you do other conversation in future, that's someone to bring in. And he's doing a lot of work in the continent. He's running the APSA chair for data science at the University of Pretoria. And there is a lot of work on how we train data sets for ourselves. And I think it's important that we learn on how others are doing it and how we build up on that. Thank you.
Thank you, Prof.
I'm not sure which issue to respond to. There's quite a lot of them. I'll just start off with the first one raised by Professor Odia, raised by our Madam Speaker here. The issue relating to human rights. When you're invited to gatherings like this, normally you look at the theme and locate your speech within the theme. So maybe I'm kind of shifting responsibility to the audience. They asked us to pitch our topics, we did, we accepted them, we felt it was articulate. But in our presentation, mine is, if I remember, we actually hinted at this human rights. I did it twice, where I actually, if you remember, I took a while talking about and automation and the right to employment. In fact, that South Africa is a country where we have a high unemployment rate. So I'm actually talking automation because it militates against availing jobs. But in as far as maybe the human rights tone did not come quite clean, we apologize. And then I wanted to my colleague there, he talked about AI as a tool for dominance and Africa's lackadaisical approach to it, and then South Africa being all over the show. I listened to you and took that as a comment, which is well noted. But I would just want to say maybe as a consolation, at the African AU level, there is movement there, a lot of interventions coming up, so we'll see we'll see an improvement on that front. But for different reasons, I don't agree with you that South Africa is all over the show. Maybe we can talk about last time. And then there was something mundane from a student. I think he says, where do I find information about this AI and its detrimental effects and so on? Now, I would just want to say to you again, you use the same AI to find it. So all information, you will find it online. And take that as a joke, right? Don't feel offended. But I'm saying most of the information you will find it online. A simple Google search or anything you want to find. It's there. The different types of technologies that you will find, and all the effects. And then there was something I thought I would not skip if I don't respond to it. I think it was the one, yes, more clear related to South Africa and Australia, whether why can they lead on that front. I want to take you back. The Australian case, first of all, what the hopeful part was a single federal judge sitting, and then he kind of said, look, we can recognize. And then the full bench then voted against us. So we're left with one leader, right, whom I said can't lead. That is us. So I'm saying, again, you can't lead on the wrong front. So for reasons I said earlier, I don't think we are ready to where we can lead. Yeah, the rest
and I think I can add on that. Thanks for raising the full bench. I looked at the first matter where actually the federal court had ruled to say yes, but the basis for that ruling was on the lack of clarity of the law, in the sense that the provision did not contain any prohibitions. So it was broad enough to be interpreted to include, AI, which is not, in my opinion, honestly, it's not a strong basis to then say, well, because the court went that way in Australia, therefore that should hold, because it still leaves room for legislative development. Is that the correct? Yes, the correct word. Yeah. So the law can actually be developed further to actually clarify that. So that was and the same is the case for South Africa. But I think in the case of South Africa, honestly, it's just a deficiency in our system that should not have been allowed. And the fact that we are a non-examining authority, that is the deficiency in our system that actually led to that, and therefore I think that matter should actually be looked at. So I think that addresses that question. Then there was the issue around the legal capacity, and I can't remember who raised that. If I'm not wrong. Yes. I think at the point where we are with the development of AI, it's not autonomous. So it still depends on input from developers, right? In as much as it learns, but how it learns, it's programmed. It's a program, right? So it depends on input from developers, but it also still depends on input from prompters. So let's say a principal. So for instance, let's say you have a home automation system, right? That allows that you say to it, when I come home, I'd like to have the heater turned on at this degree, etc. At the first time, it will learn to say, okay, when this person comes in, he comes in at around 5:30. So maybe 30 minutes before I need to set it up, so that by the time that she comes home, then the heater's on, and that's how AI would work. But then maybe over time it realizes, hang on, the time is changing, right? But the setting still remains the same. So it still takes the prompt from an external principle. So it still does not have that at this point, right? It still does not have that. We don't have AI that has absolute autonomy, right? And as Dr. Marcus had mentioned earlier on, is that also it gets developed for specific, it's still getting developed for specific purposes. In as much as I think over time we will probably get to a point where you can have AI that can be, who knows? You can never say no. So I think that part makes it very difficult to provide it with, or to confer it with legal personality the same way that you would a natural person.
Yes, I mean, the term that we actually use is that AI is narrow in the
technicals in this design. And that's why I showed on the supervised and supervised, there's still a specific application you're deploying it for. Of course, one might want to use it for something else, but you are actually trying, and that's why I use the analogy of planes. I was trying to make the point that these things have design limitations, and that's what they are.
Okay, thank you for that. Unfortunately, colleagues, I will not take any questions further. And I know initially I had said that we also allow our moderators to reflect, but due to time, we can't. So this is what is going to happen. Our students who are present here, once we are done here, they will assist you outside. And then our colleagues, once Director, Advocate Rapata, is done rendering the last item, which is vote of thanks. Immediately when it's done, then he will lead us out. Then the colleagues from the stage then will follow him, and followed by the colleagues on the floor, and students will remain, and they will assist you accordingly. With that said, Director, can you come and render that last item, please?
So, good afternoon. Matzimai never room. That means, ladies and gentlemen. Okay, just a little undertaking that you not interfere with Mike as I speak. For me, not to stop the lunch. I've been favored with some privilege of having the authority to decide that. So please do not interfere with the mic. There are a few things that I think I need to talk to. And the first one is up there. I'm going to say this because we are the University of Limpopo. And somebody is trying to sabotage your lunch. Okay. So, very briefly, we are the University of Limpopo and we are grounded in thought and theory, particularly when it comes to breeding new leadership, a new generation of academics. And it starts with our behavior, how we conduct ourselves. Mutanam, in the future, you must distinguish between addressing your contemporaries and addressing elderly people. And I hope that message goes to everybody else. When you talk to your elders, you can't be talking to them and saying and all that. It comes with artificial intelligence. There's a lot of that on TikTok, on YouTube, but we shouldn't actualize it as part of our lives. It's not a good trend. Let us appreciate the leadership of the university, Professor Mahalong and the Deputy Vice Chancellors, Professor Madaji and Professor Singh. Professor Madaji was here earlier and he said he would not be here for too long because he had other commitments to attend to. I had anticipated that he would not sit here for longer than 30 minutes. But because of the intriguing nature of the presentations and the speakers, he could not afford to leave. So I hope that our Deputy Vice Chancellor is still safe. Because he abandoned other duties because of you, the speakers. And of course, we also to appreciate the leadership of faculty and of course other executives in other divisions in the university, with Professor Sibanda being in our midst here, and the collective in the School of Law, the HODs, all the colleagues there. And then we also do have colleagues from other universities and of course the technology transfer division of the university. We can't understate their role in making this event possible today. By orientation, I come from public law, and you know, I'm very grateful that the organizers did not put any one of us in the program because I suspect they knew that there would be a lot of critical theorizing. You would see it. I mean, when you look at the theme that they formulated, you can see they did this deliberately to confuse some of us, Professor Odegu. They talk of intersections. Immediately you start thinking of roads. And then they go on to speak of artificial intelligence, intellectual property, and human rights. Well, in public law, when we look at this, we saw in public law, we saw technology, law, and ownership. We just don't understand why they try to complicate it. That is what we're talking about actually today. And the presentations were quite fascinating. You were saying to the people, here's technology, this is how it is developing. And then you have the law. How must the law respond? And you went on to raise a question about this question of legal personality. Speak to the question of ownership, by the way. Can a machine own? Can a machine own? So it belongs to the Department of Mercantile and Labor. Oh, they try to be complicated today, it's okay. They accept that. And all this, we would love to appreciate Professor Sizwe. I will finish, just be patient. Professor Lonius Dobu. And by the way, Professor Sizwe Snail Gamtuse, yeah, I've today seen that you really love University of Limpopo because you kept on mentioning it as a majestic, marvelous. You are welcome, come here. And we also have Professor Lonius Dobu, my dear brother, and Madam Mudiwele, and Burendani Mampiswa. We heartily thank you for sparing a moment to come and be with us. It was quite exhilarating indeed. We've learned something. And I'm sure our masses are quite empowered. And of course, we should not forget those that have joined us online. We are seeing them and we hope that they were empowered as well today. So, let us also appreciate Mr. Ngwane and Mr. Rivilo for their moderating role, and yourself, Mr. Program Director, and the organizing team. With all these few words, here's the University of Limpopo. Each time we have events, we make sure people eat. Because we understand that food is the source of energy, so after this, you still have other things to do, you must still be empowered. And then I'm sure we'll engage further after this. So all of you present here today, we deliver our hearty thanks and we shall have a good day further. We adjourn. See you next time.